And now it's the turn of the lawyers. Three of them. I'm sure there are lots of jokes about having a surfeit of lawyers, but good to see you again. George, nice to see you. I suspect we may well run over time as well, but we'll try not to. Is everybody mic'd up? Yes, we've got George Kleinfeld from Clifford Chance, Patrick Murphy from Clyde Co, and Will Thomas from Eversheds. Gentlemen, be succinct in the best lawyerly style. And this session is understanding the post-sanctions legal landscape. And I notice they're all suddenly leaving. George, after you.
Thank you. Good morning, everyone. I do have some slides, but since from sitting in the back of the room, I know that they will be illegible to many of you. I'm happy to proceed without them.
Excellent. Don't kill people with PowerPoint. Excellent.
In the next 10 minutes, I'd like to talk to you about a common concern shared by 99% of us in the room. That concern is based on our collective view that the JCPOA is truly a historic accomplishment and is an indispensable potential contributor to stability and peace in the Middle East. And the concern is that the JCPOA is in trouble. And I'm going to talk about what I think most of us believe is the primary source of that trouble, which are a range of transition issues arising under U.S. sanctions that weren't anticipated by the negotiators. Despite the 10,000 years of Iranian negotiating skill, there was a slight failure to recognize the issues that have arisen. We'll talk about what those issues are. We'll talk about the challenges confronting the business community internationally, managing U.S. sanctions risks, and anticipating and addressing these transition issues, and conclude with some views on the potential future course of the JCPOA. To begin, let's look at the world as of January 15th, 2016, from the lens of U.S. economic sanctions, one day before implementation day. As of that time, as they had for many, many years, if not decades before, the U.S. maintained a strict regime of so-called primary sanctions. The primary sanctions essentially prohibited the involvement of U.S. jurisdictional elements in most forms of trade and business with Iran, unless the U.S. Sanctions Authority, the Office of Foreign Assets Control, the OFAC, had licensed or authorized that business. U.S. jurisdictional elements are a very broad concept, particularly when interpreted by highly aggressive U.S. enforcement authorities, not only OFAC, but U.S. bank regulators and U.S. criminal prosecutors. The jurisdictional elements that the primary sanctions precluded from involvement in Iranian trade and business included any U.S. person anywhere in the world, including U.S. passport and U.S. green card holders working for non-U.S. companies outside the U.S., any exports of export-controlled U.S. origin goods, as well as re-exports of such goods by non-U.S. re-exporters to Iran, and most powerfully, the U.S. financial system. Any payment sent in U.S. dollars from a remitter outside the U.S. to a beneficiary outside the U.S. will almost always clear through U.S. correspondent bank accounts in Manhattan, thereby providing a range of U.S. enforcement authorities, including at the level of New York State, with enforcement jurisdiction over not only the payments, but the non-US parties to those payments. In addition to these primary sanctions, which, by the way, resulted in billions of fines, primarily directed at non-US banks who had sent such non-US person payments in US dollars on behalf of non-US clients through the US financial system, we had, beginning in 2010, an increasingly intensified campaign of US secondary sanctions. The US secondary sanctions were a very entrepreneurial approach by the US government to the inability previously of the United States to address transactions that did not involve US jurisdictional elements, but were perceived to benefit the Iranian economy in ways that were inconsistent with US foreign policy objectives. And what the secondary sanctions provided was authority for OFAC and the State Department to designate and thereby blacklist any company or person globally engaged in entirely non-US business in non-US dollars with Iran in ways that were sanctionable under the US secondary sanctions. And the US secondary sanctions reinforced sanctions applied by the European Union and other countries who shared US concern about nuclear proliferation in Iran. So there was a community of interest in using sanctions to achieve what was ultimately achieved, which was the Joint Comprehensive Plan of Action. Now, the Joint Comprehensive Plan of Action required Iran to meet certain threshold non-proliferation obligations, which Iran met more quickly than anticipated, resulting in Implementation Day on January 16th. Implementation Day meant sanctions relief. Now, the sanctions relief offered by the United States included the reduction significantly of most US secondary sanctions, thereby enabling much greater non-US trade and commerce with Iran, free of the risk of a US secondary sanctions designation, but relatively little relief from the US primary sanctions. If you're in the aviation parts or airframe manufacturing sector, there is the ability now to obtain an OFAC-specific license to export your goods and services to Iran. If you're a non-US subsidiary of a US company, there's now something called General License H, which, subject to a long list of restrictions, enables you as a non-US subsidiary to engage in business with Iran that was previously prohibited under the primary sanctions, as long as you do not involve your US parent, any other US persons, the US financial system, or US origin goods in that business. Those restrictions reflect the continuing broad range of US primary sanctions. Now, what was the intended consequence of the US sanctions relief? It was to enable Iran to receive the economic benefit of achieving its non-proliferation objectives through new opportunities to engage in trade and commerce with Europe, Asia, and all of the world but for the United States, subject to the exclusion of US jurisdictional elements from that business, unless licensed by OFAC, and subject to respecting a certain limited range of secondary sanctions that remain in place, particularly relating to the avoidance of transactions with the IRGC and approximately 200 other OFAC-designated SDNs. That was the intended result. It hasn't worked out. The reason it hasn't worked out is because when Iran was negotiating the deal, the risk that they anticipated was that the United States would find new ways to replicate the effect of the sanctions that the JCPOA required the US to remove. New forms of regulation, new forms of intimidation and pressure sponsored by the US government. But that, in actuality, is not the problem. The problem is the sanctions that Iran agreed and accepted that the U.S. would continue to maintain. The problem is that those primary sanctions, in particular, have unanticipated restrictive impact on entirely non-U.S. trade and business with Iran in ways that would require much more time to address in detail. Now, Secretary of State Kerry and other senior Obama administration officials have used the power of the podium to exhort non-U.S. companies, non-U.S. financial institutions, not to fear that the U.S. would impose sanctions for activity that is now permissible. The U.S. government has issued reams of guidance material. OFAC has worked very hard to publish guidance explaining what's now permissible. The problem is not that European financial institutions and other key facilitators of non-U.S. trade and commerce cannot legally support non-U.S. trade and commerce with Iran. That's not the problem. The problem is that they will not support U.S. trade and commerce with Iran. It's not so much a legal prohibition, but a primal fear that is the product of years of hyper-aggressive enforcement action relating to a period of time when mistakes were widely made among the non-U.S. financial services community in regard to their involvement of the U.S. financial system in otherwise non-U.S. trade and business with Iran. So how do you placate this primal fear? That's one big challenge. The second big challenge is that even among the financial institutions outside the U.S. that are willing to do it, that are not among the won't do it population, they are facing some unanticipated can't do it problems. Principal among those is the unwillingness of the big U.S. financial institutions, the financial institutions that you need to be able to do business with if you are a bank somewhere else in the world in order to be credible suppliers of banking services to your clients. Those big U.S. banks have told many financial institutions in the parts of the world where one might expect to see banking support for trade and business with Iran, the GCC countries, other parts of the world that are geographically proximate to Iran, etc. They've been told, from a U.S. financial institution perspective, we don't want you to do business with Iran. We know you won't do business with Iran using our facilities because that's prohibited, but we're simply concerned that we expose ourselves to a range of legal and political and reputational repercussions if we are perceived to allow non-U.S. financial institutions both to do business with Iran and to do business with us. A very unexpected can't-do-it problem for non-U.S. financial institutions that will always choose partnerships with U.S. financial institutions over new business with Iran. So, we have a range of unanticipated consequences. We have extreme frustration within Iran and outside Iran among the business communities that expected to benefit from this agreement regarding the inability of business outside the U.S. to obtain financial services without which long-term infrastructure, energy sector, and other major projects in Iran cannot take place. So, does this mean it's the end of the road for the JCPOA? After all, we can hardly expect to Iran to remain committed to its side of the deal if its population feels that they are not receiving the benefit of the bargain. Some days I'm pessimistic. I open up the paper, very pessimistic. Some days I'm optimistic. Today I'm feeling a little more optimistic. Partly it's the huge turnout today, but partly because Europe, in my view, controls its own destiny here. At some point, it's going to wake up and realize that it needs to be more vocal. It needs to be more vocal in response to the mythology propagated in the US Congress and among lobbying groups who want to burn the house down, who want the JCPOA to go away, and see their ability through political opposition to prevent the Obama administration from managing these transition issues as a way to achieve what they couldn't achieve last September, which was a congressional block of the JCPOA. Now, the mythology to which I referred is the perception that there's an alternative to the JCPOA in the form of a snapback of U.S. secondary sanctions and the imposition of even more comprehensive secondary sanctions that we had before, which would bring Iran to its knees, and Iran would capitulate in response. And in my view, this is a myth because I don't see Iran capitulating in that circumstance. But more importantly, it's based on the false premise that the European toleration and the toleration of the rest of the world for U.S. secondary sanctions that prevailed before implementation day would continue to prevail post-implementation day. That false premise is based in large part on European silence. Where are the European voices standing up and saying, there is no possible way we will allow the U.S. Congress or anyone else to destroy a deal that we, the Europeans, are as equally proud of accomplishing as is President Obama. And we will not have President Obama after next January, but we will have Angela Merkel. We will have other European leaders. If they make it more widely known that they don't intend to tolerate the United States coming to Europe and threatening to blacklist the leading European banks and leading European industrial companies simply because they're engaged in entirely legal European business with Iran that doesn't break any laws because it doesn't involve any U.S. jurisdictional elements or any SDNs or other recognized and accepted restraints, then the myth will be exposed, the myth that there's an alternative. Thank you for your time. I'd like to invite Patrick to give you a true European perspective.
George, that was tremendous, and a very good question to pose to Angela Merkel and actually all the Europeans. Patrick.
I'm just going to flick through George's slides. If only to give me a prompt for my own talk. Thanks very much, George. I just want to start off by drawing a couple of comparisons and distinctions between the EU regime as it was and the US regime, because I think it's quite instructive when we consider the potential snapback risk. The EU sanctions were never as rigid as the US sanctions. There was never a blanket ban on trade between Europe and Iran in the manner that the primary sanctions were. If you were not operating in some of the restricted areas, which I've got up on that slide, prima facie you were permitted to do it under the EU sanctions. The other principal distinction was that the EU never legislated extraterritorially. It never sought to tell non-EU persons what they could and couldn't do. The similarities came in firstly, the actual areas which the EU did target. That was primarily a pragmatic reason to make sure that the US and the EU were never contrary to each other. There was never a situation where the US was legislating and telling EU companies what they couldn't do when it was legal as a matter of EU law. It avoided any Helms-Burton-type difficulties that we saw with Cuba. The second similarity is between, as the EU sanctions were ratcheted up, there was a de facto blanket ban on trade between Europe and Iran. Because of the targeting of the financial sector, it became almost impossible for many EU companies to carry on doing what on paper they ought to have been able to do. And the final similarity in the end is that the EU sanctions ended up having actually quite a large extraterritorial application. By targeting things like the insurance market, very prominent in Europe, and which people well outside Europe needed to be able to carry on trade generally, including with Iran, they started having these consequential effects which tightened that trade with Iran. So how have the EU sanctions changed? Well, the insurance and financial restrictions which were in place up until implementation day have gone. The restrictions on SWIFT and financial messaging services have gone. The oil sanctions have gone. The restrictions on oil and gas equipment and joint ventures in the oil and gas sector have gone. Diamonds, gold, precious metals, shipping sanctions, and even the trade in precious metals, raw and semi-finished metals, have all been lifted to some extent. What are the residual things you still need to worry about, though, as an EU person looking now to start doing business with Iran again? Well, firstly, you do have to be very cognizant of the residual designation-based sanctions. You've got to do your due diligence. I'll talk a bit more in a moment about what sort of due diligence you have to do. And you've got to remember that even though the trade with Iran in raw and semi-finished metals, for example, and even some nuclear items has been lifted, you still do need authorizations in order to carry on that business from the competent EU authorities. And finally, of course, there still are blanket prohibitions on trade in military goods. So the live issues you've got to think about, firstly, your counterparty risk. Who are you dealing with? The next slide we'll look at in a moment is the sort of questions you've got to ask about due diligence from an EU perspective. You've got to think about the technology transfer risk still if you're dealing with goods which are potentially controlled. You've got to know your own goods as well as know your customer. It's a lot easier now than it was, but it's still something to think about. Then we get into the practical difficulties. Most importantly, can you get paid? Is this a trade in which you're going to be actually able to make money? And that is a function of the continued banking problems that George has talked about already. It's an issue you've just got to talk about with your banks. And even if you can find a bank that will get money in and out of Iran, you've got to ask the question, what about my other banks? What about the people that are kind enough to lend me money? Do I have restrictions in my facility agreements which might preclude me from doing this trade with Iran, even though, on the face of it, after 16th of January, it's perfectly permissible? So you've got to have those conversations with the banks and look at the terms of your facility agreements. See if you can get waivers. Can I get insurance? Very prosaic, but if you need heavy indemnity insurance, for example, you've got to ask the question, does my insurance policy have any restrictions which might influence me? We'll look at a moment in how that might work. And then finally, snapback. Here's the Donald to remind us that there are still risks, and you've got to plan for the future. You've got to have thought about your potential exit. How can you plan for that? Can you have a snapback clause or a force majeure clause which can offer you some protection? And even if you do, you've got to think about the limitations of that clause. Will it ever be enforced in Iran if you have to look to perhaps defend yourself in a claim in the Iranian courts? Is it going to be upheld as a matter of public policy in Iran, allowing you to extricate yourself from the deal you've concluded? I want to say one very quick thing about insurance. This is a graphic illustration of the reinsurance position of something called the International Group of P&I Clubs. It's simply an example to show you how complex this is. If you have an insurance policy, it's simply an agreement between you and your insurer. But behind that, there are layers of reinsurance. And the point about this is to look at these layers of reinsurance as the claim gets potentially bigger. There will be, certainly in this scheme, a clause which restricts what you're able to claim from your insurer if any of those layers of reinsurance involve US persons. So even though under the EU sanctions relief you can now get insurance that is in relation to Iran, you've got to be aware that you might still be on the hook for a portion if you get into those reinsurance layers, which you cannot recover, and you have a potential liability there. So you've got to think about that as you move forward. So the crucial question of due diligence now, what do you have to do? It's really not a static, but a very dynamic question. You've got to look at what sort of trade you're involved in and where you sit in that trade in terms of exercising your due diligence. From an EU perspective, the thing you've got to worry about is making funds and economic resources available to EU-designated persons, the people that are the EU equivalent of the SDNs George has talked about. You cannot make them available directly or indirectly. Now, the standard you've got to think about is knowing or should have known. But don't get too hung up on the should have known. You're talking about dealing with Iran. There's an extra layer of due diligence required because of that. It's not going to help you in front of regulators at a later date to say, well, I was dealing with Iran, but I couldn't possibly have known that the person I was dealing with had links to the IRGC, for example. So, firstly, do you know who your customer is? But more than that, who owns and controls that customer? Because we're talking about directly or indirectly here. Do you know who the UBOs are? Do you know who the directors are? If not, ask those questions and ask for evidence. Then run those people through your compliance checks to make sure they're not sanctioned. Is it relevant to ask who your customer's customer is? It might be in some circumstances, because again, we're talking about directly or indirectly. So you've got to be sure that you're not making these funds and economic resources indirectly available to your customer's customer. Are there any other reasons for suspecting you're dealing with a designated person? If a simple Google search reveals it at a later date, you can be pretty sure that the regulators won't be very sympathetic to you. You can order a pizza on Google, you can do some due diligence, and if it's easily available to you at the time, that's going to be something that will be held against you later. And finally, having done all this due diligence, don't just throw it away, keep it. You might need to refer to it at a later date to defend yourself, and keep redoing it at regular intervals. It's no good doing it once at the outset and then forgetting all about it. So, I want to just quickly go through a couple of different case studies looking at this. We're thinking about sort of situations we've been involved in at Clyde Co, looking to help people get into Iran. The first case study, very simple and easy one, maybe an EU-based FMCG manufacturer looking to appoint a distributor in Iran. Okay. Of course, do your due diligence on your distributor, know who the UBOs are, know who the directors are, and run those compliance checks. But in this case, is your customer's customer likely to be a problem? Probably not. Your customer's customer is likely to be consumers. It's not going to be as high risk an area as we're going to look at in the next case study. So it's probably not, on that scenario, something you need to be concerned with as much. You do need to think about your banks getting the money in and out, but also think about ways of restructuring that distribution agreement so that you don't have to worry about the banks. Think about appointing a distributor outside Iran. In the UAE, there's many companies which have links or feet in both camps, as it were. And you can appoint distributors outside Iran, you can get paid outside Iran, you can even transfer title to the goods outside Iran, so the insurance and the transport issue becomes the problem for the distributor. They're likely to have more easy ways of getting it into Iran. Then, of course, think about snapback. What are your risks in this scenario? Your risks are going to be fairly low. It's probably going to be limited to your outstandings at the time of any snapback, if that happens. It's a credit risk problem. All you're likely to lose is the value of the goods in country if you're unable to get paid. The second case study, much more difficult situation, a joint venture for a major infrastructure project. Now, here the due diligence considerations change a bit. You've got to think about your customer's customer here. Going in as a joint venture partner, you've got to do your due diligence on them. But of course, the joint venture company is going to be providing services in relation to a project. You've got to know that you are not indirectly providing funds and economic resources to the project employer. So you've got to do the due diligence in that way. You've got to also consider potentially technology transfer risk there. The banking issue will be much more live, fewer ways around it. It's likely to require a change wholesale in the attitude of the banking community in order to get the money in and out. So that's still going to be a lingering problem, as is the insurance. You're going to need some quite hefty and well-capitalized insurers behind you. There could well be gaps on the basis of the diagram I showed you earlier. And then, of course, snapback. That's going to be a much more dangerous issue in this circumstance where you've got capital in country that you might want to get out. One way of potentially looking to mitigate that risk is perhaps having your joint venture in an offshore company. You've got a lot of things to think about. Will's going to talk about the BIT and double taxation issues, but it at least offers you perhaps an ability to structure an exit with some put-call options maybe that allow you to exit in the event of a snapback, perhaps come back into the joint venture at a later date. But it's one thing to think about in terms of mitigating that risk. So just some takeaway points, really to stress, due diligence is absolutely fundamental. Not just on your counterpart, but potentially on your customers' customers. The banks, as ever, an issue, and if you can get around it in ways which avoid appointing distributors perhaps offshore, that's one way to deal with it, but it's going to be an issue for some time yet, as is insurance. I think we carried out a straw poll recently on the London insurance market. I think 85% of the respondents in that straw poll indicated that they still had concerns about the Iran links. And until the US dollar issue is sorted out, that's going to carry on. And then finally, the Donald at the end to remind us snapback is still an issue, but plan for it. And be aware that there are inevitably, in whatever force majeure or snapback clause you implement in your policy, there's going to be risks, and you've got to manage those risks going forward. There we go, in time.
Thomas of Eversheds.
Sorry.
Ladies and gentlemen, good morning. It's a great pleasure to be here, and I'm grateful to the organisers for the invitation to speak. You'll be pleased to hear that I'm the last of the lawyers, at least for the moment, I believe. Now, my panel colleagues have focused mainly on due diligence around sanctions, and rightly so, of course. I'm going to touch on something slightly different, because I think if you're investing in Iran, I'd suggest that sanctions is just one level of due diligence that you need to be contemplating. What about your due diligence in terms of investment protection? So, simply put, how can you manage the risk of your investment being impaired, even taken from you through some kind of state action or adverse regulatory change? That's the question I want to explore with you for the next 10 minutes or so. And I want to try and answer that question by looking at three legal prisms, if you like. First of all, I'm going to focus on Iranian national legislation already in place which governs foreign investment into Iran. And here what we're talking about is the well-known FIPA, the Foreign Investment Promotion and Protection Act of 2002, which many of you will be aware replaced the previous LAPFI law from the 50s. That in itself guarantees certain protections to investors. Second, I want to turn to investment treaties. What do I mean by an investment treaty? I mean a state-to-state treaty, which can be bilateral or multilateral, whereby each contracting state party promotes and provides certain protections as regards investors from another contracting party to that treaty. Those protections can be against outright seizure, or they can be against more indirect forms of interference, whether by regulation or otherwise. And the key point to these treaties is in the event of a dispute, investors can exercise their rights through the right to bring investor-state arbitration. That's a very compelling and powerful tool. And lastly, but not least, I want to talk about contractual protections in a very simple plane, the contractual plane. When negotiating and drafting your underlying contracts, how can you best build in contractual clauses that maximize your position and mitigate against risk? Mr. Van der Veer pointed already to that earlier this morning. So those are the 3 points I want to touch on. But before I kind of break those out, I just want to focus on a couple of general threshold points regarding investment as a whole, foreign investment into Iran. The basic starting point, as most of you will be aware, is that admission, importation, utilization and repatriation of capital is controlled by OITI, the Organization for Investment, Economic and Technical Assistance of Iran. Now, crucially, OITI approval is required to qualify both for local FIPA law protection and for investment treaty protection. And that OITI approval is granted by way of a so-called FIPA license, which I'm sure many of you have heard about. It grants that in both instances, whether it's for FIPA law protection or BIT protection. So the short point is that the FIPA license constitutes a formally required approval for a particular investment by a particular investor. Article 1 of FIPA sets out what qualifies as a foreign investment and a foreign investor. And perhaps more interestingly, Article 3 of FIPA specifies and splits out the kind of investments that may be protected. And that breaks down into two. We're essentially either talking about FDI, i.e. equity investments in areas that are open to the Iranian private sector, or we're talking about foreign indirect investment, i.e. non-equity investment forms under specified contractual arrangements in sectors not generally open in the same way to the private sector. So here we're talking about contracts such as the buyback or the new IPC in a sector such as oil and gas. So that's just by way of general framing. Let me then come back to the first of the three options I outlined for you. Let's assume you do get yourself a FIPA license. What protections does a FIPA law itself offer a foreign investor? Well, the two key protections are those at the top of the screen. National treatment standard, basically a promise that you won't be treated any less favorably than a local investor. And then a fairly standard protection against expropriation or nationalization. But what about in the event of a dispute? How meaningful are those protections? How do you exercise your rights? How realistic is it for you to exercise your rights under the FIPA law as an investor? Well, that comes to the settlement of disputes clause, which I've got up on the screen there, which bears noting. It reads as follows. Disputes arising between the government and foreign investors, if not settled through negotiations, shall be referred to domestic courts unless the law ratifying the bilateral investment agreement with the respective government of the foreign investor provides for another method for settlement of disputes. Now, commentators have suggested that that is pretty vague and arguably unsatisfactory from an investor's point of view, and I tend to agree. What you don't have there is a clear guarantee of an effective and neutral dispute resolution mechanism. In short, what that's telling you is it's only if there is an applicable bilateral investment treaty that you're necessarily going to have access to investor-state arbitration. So I'd suggest that clearly points to the importance for investors of not just relying on your local FIPA law, as some investors I know are doing at the moment, but also trying to harness the other two options I set out at the beginning, namely bilateral investment treaties and also simply contractual protections. So let me, with that in mind, turn to the second of the options I set out, which is investment treaty protection. Now, the general context here is that Iran has a very extensive network of investment treaties. It has over 50 BITs signed. It has over 60 signed and over 50 in force. It's party to, I think, over 2 multilateral investment treaties as well. And what's interesting is we've seen more and more of these treaties being signed in the last couple of months. If you've been watching the news, a new treaty with Japan, a new treaty with Singapore, a new treaty with Slovakia, there's going to be more and more of this in the coming months, and there's a reason for that. So the question for you as prospective investors is, how do you take advantage of that network? Importantly, investors need to meet certain key jurisdictional criteria to qualify for protection under these treaties. The first of those is this key definition of investment. Now, that is actually normally in most Iranian BITs a very open, non-exhaustive list, easy to come under. But the key point is you'll only meet that definition if you have OITI approval, i.e. if you have a FIPA license. There are many investors in Iran who think they've qualified under a BIT, but they haven't because the person who might bring the claim hasn't got the FIPA license. Definition of investor, also very important. In Iranian BITs, like most BITs, the investor definition includes both natural persons and legal persons, i.e. companies. But unlike in some more liberal BITs, under Iranian BITs, the definition generally only includes companies with their genuine economic activities located in the other state that has signed a BIT with Iran. So what that limits is the practice of what we call investment treaty structuring, a bit like tax structuring, whereby an investor might seek to take advantage of an advantageous BIT between state X and Iran simply by routing its investment or rerouting its investment via just a shell company or a mailbox company in state X. The point to take away here is Iranian BITs won't let you do that. They are written such as to prevent what we call their treaty shopping. But let's assume you do qualify. What are you qualifying for? Well, in a nutshell, most Iranian BITs offer the same kind of standard substantive protections that we see in most BITs around the world. There are some nuances, I should stress. I don't have time to get into them now, very happy to talk about it. But the bottom line is you will be qualifying for things such as protection against expropriation, a guarantee of fair and equitable treatment, a guarantee of full protection and security, and so on. And then a key point, again to note, is what you're then offered in the way of dispute resolution if you need to exercise those rights. Most Iranian BITs offer either a choice between local courts in Iran or investor-state arbitration. As an investor, you can see why that's compelling. That in itself is an important protection, that option to take Iran, if need be, to investor-state arbitration. And what you should be aware of is we've already seen an investor do this recently. In the well-known Turkcell case, a Turkish telecoms investor took Iran to arbitration. It actually lost that case. Iran successfully defended that case. But what you should take away from that is that Iran, unlike some nations around the world, is standing by its BIT commitments. It didn't run away from that process. It engaged fully in the process. So again, I think investors should take that as a comfort. These protections shouldn't be treated as meaningless as perhaps they are in Venezuela or Bolivia and places like that. Thirdly, and briefly, let me look at the last option that I set out for you at the beginning. Contractual protections. The key example of this is, of course, dispute resolution. The basic point is international arbitration is generally preferred by foreign investors over local litigation. And that's just simply because it provides, it's seen to provide a neutral forum for contractual dispute resolution. So investors invariably prefer it. Now, depending on your negotiations and the bargaining strengths, that arbitration provision can result in the arbitration being seated anywhere, under any arbitral rules, under any governing law. It comes down to the negotiation. But what I would stress is if you as investors start to find yourselves pressed by Iranian counterparties towards Iranian-framed arbitration, as it were, you should note that Iran itself has a relatively well-developed arbitral framework. There is a well-advanced Iranian law of international commercial arbitration from 1997. It's based on the Untitled model law, very close to that. Iran ratified the New York Convention on Enforceability of Arbitral Awards in 2001. And Iran itself has two well-known and relatively well-established local arbitral institutions. Now, one important point to note with respect to arbitration, whether you're looking at arbitration within or without Iran, is Principle 139 of the Iranian Constitution. That provides that for contracts involving foreign investors and Iranian public property, referral of disputes thereunder to arbitration requires the prior approval of the Iranian Majlis. Now, that provision remains open to significant debate, because there is a debate as to whether that means you need to get approval each time you want to take something to arbitration under a contract, or whether it's just at the beginning when you put your arbitration clause in that contract. That debate is ongoing in Iran. If you're an investor, it's a fair question. My understanding is that Iran is conscious that some clarity on that would be helpful to an investor. So watch this space. But lastly, what about other contractual protections to manage risk? Well, Patrick's already spoken to this, and Mr. van der Veer mentioned it earlier. I would suggest that force majeure, stabilization, renegotiation clauses all merit careful consideration in any investment contracts concerning Iran. And then, of course, as Patrick's already spoken to, and I won't repeat, there is the question of snapback. How are you contractually going to provide for the possibility of snapback within your contract? Or do you just see it as a country risk? Does it depend on your contract? That's the question. There's no right answer there. It's going to come down to your contract, and just as Patrick said, your particular case scenario. But what I'd also emphasize and endorse is what Mr. van der Veer said earlier. When you're negotiating your contract, when you're looking at these important clauses to manage and mitigate risk, be very careful about the wording and what wording might mean to you as opposed to what wording might mean to your counterparty. Let me just wrap that up. I think my takeaway message for you would be this, and it's a theme that has been run through, I think, the last 2 or 3 sessions now already, which is do your due diligence. The devil is always in the detail, but the devil is really in the detail here. Do your due diligence, whether in terms of investment protection via the FIPA law itself, whether via bilateral investment treaties, and or via contractual protections. The bottom line for you as investors, my advice to you as potential investors, is make sure you know what cards these different options do and don't give you. And most of all, make sure you know how best to play them, where best to play them, and when best to play them. Thank you very much.